Hi, my name is Janice Switlo, and I'm a prolific reader and researcher, and I've got a lot of books on the go right now. So instead of trying to pull topics from a few of these books, I want to actually finish up with this particular book that I've been using and referring to, and I'm going to run through the quotes from start to finish kind of thing and comment either as I quote them or towards the end. And so this book that I've been mentioned before is The Canadian Revolution from Deference to Defiance by Peter C. Newman. And there's a number of illustrations I like to share. That, you know, in the term of when the Constitution Act 1982 was signed off on, you know, it was, this author reports that both Her Majesty and Prime Minister Pierre Elliott Trudeau recognized that they were taking part in a defiant act. The Queen called it a, quote, a defiant challenge to history. The Prime Minister described it as, quote, an act of defiance against the history of mankind. I think it's a very telling remark on the part of Prime Minister Trudeau at the time. Mankind, right? I think he knew full well what his plans were in terms of, you know, finishing off with the Indian problem. Because it's a defiance against history of mankind, right? Creating this new subcategory, a lawful new subcategory that doesn't depend on the doctrine of discovery per se, right? But carries the same foundational belief system, if you will. And that is that, you know, it was okay to simply come to the country of another nation and, in the case of the French, you know, plant large crosses, you know, in case of others, plant flags, and say that was enough to give us ownership. So, you know, knowing that the Indigenous nationals were not going to sign off and say, yeah, fine, conquer us. Knowing that the treaties are critical and foundational constitutional documents for the initial exercise of partial limited political sovereignty, you know, Trudeau had to come up with something that was going to make this happen. So that, you know, the control, the ownership, if you will, would be firmly in the hands of a prime minister, for example. And, you know, it's almost looking like his son will be the first to hold that role. Hate to say, but this is where the direction it's going. You know, and numerous times I've referenced that Indigenous nations were not conquered in this area known as Canada. And, you know, many authors are aware of that as too. You know, here he writes, Indians have always been the ghosts of Canadian history. The original First Nations were not conquered in battle like the American Sioux, nor, and with the exception of Newfoundland's Beothuk, were they hunted for sport to extinction like the Tasmanians. Still, their lives and spirits were torn apart by the arrival of the Europeans. They became the Palestinians of the New World, displaced within their own homeland, forced to live in enclaves under the rule of an intrusive majority of quote-unquote newcomers. But what I find interesting is that this author is not born and raised in Canada, but came to Canada in 1940. He was raised in Czechoslovakia. That while he'll make that kind of a comment, he'll then not appreciate at all that these are actually nations. So he says, all, you know, all that change covered by this period of this book. This book is dealing with Canadian history of 1985 to 1995. And it says that the First Nations, fueled by white guilt that stressed the plight of discontented minorities. Indigenous nationals are not domestic ethnic minorities. They are nations. They are nationals of their nations. What Canada tries to do is to change that into Indigenous nationals becoming merely domestic ethnic minorities. So it says the Indian cause suddenly became fashionable. There's nothing fashionable about this at all. It's actually constitutional. It's a matter of law. It's a matter of human beings. It's a matter of rights and ownership of property and resources. And it goes on to say that, you know, this is at the end of the decade. It seems it's a distorted verdict to speak of Indian gains when so many failed to achieve a better life for themselves. This concept, you know, that this reinforces that it's your fault, you know, that you didn't, you know, make a better life for yourself. How, when constantly under priming to undermine your confidence in knowing who you are. All of the things that have happened in these continuing attempts to conquer and to get you to abandon. When I read this kind of stuff, and I'm sorry this is upsetting to you, quite likely, hearing this, but it's important to understand, you know, this is current. This isn't old, you know, old writing. And this is what's held up to be accurate historical writing. And he basically said to be a Canadian Indian was to be dispossessed. Again, Canadian Indian, not Indigenous national. And he says, you know, at the same time, the First Nations won the right to self-government. This concept that, you know, they don't have it, they have to be given it, they have to earn it, they have to somehow achieve it or get it. That's what's underlying all of the documents that Chief and Council are being asked to sign and the processes they're involved in. It's all about, well, you can get it if you come and do it as we say you should do it in order to get it from us. Let's be clear, Creator put you here. You have all the powers of governance, you have all the powers of owners, subject to your Indigenous laws, of course. And continuing from a political perspective, these negotiations under the self-government policy granted the various First Nations de facto status as self-governments, a status which was recognized when they signed treaties with the Europeans and which they insisted had never been relinquished. So at least he's acknowledging this history of preserving and remembering, at least in this time. Are those in positions, elected positions today, are they remembering that they're actually part of a nation? That they are not just something that is decided to be allotted to them by another government. And this is interesting, he's mentioning what happened at Oka. And, you know, and he's talking about, from the Canadian perspective, what was happening. The deferential Indians of Canada's past had learned how to negotiate at the end of an Uzi. Quote, they demanded what no responsible government could ever concede, that Canadian laws no longer apply to them and that the Mohawks community be recognized as a separate nation state. End of quote, complained Bernard Roy, the former Mulroney aide-de-camp who became the chief federal negotiator in the crisis. Mohawk conditions included the right to enter into free trade arrangements with other countries, exemption from Canadian personal, corporate, and sales tax, and the ability to levy tariffs on goods and services passing through their territories. Now let's be clear, Indigenous nations still possess economic sovereignty. There's no treaty where that's been given up. And it's not a matter of asking for Canada to agree that, for example, they have the right to enter into free trade agreements with other countries. That exists. That's a power that an Indigenous nation can exercise. Not a community within that nation, the nation itself. This is why it's so critical for Indigenous nationals to understand there's so much more than members of an Indian band. It is only through the exercise of the nation powers that those kinds of rights and powers can be exercised. This is why it's critical to not allow yourselves to be broken down into these new legal entities created under federal and provincial laws. Because of course, in that capacity, there is no ability to do any of that. And here, remember, I opened this one with this discussion about how Trudeau saw the passing of the Constitution Act 1982. And here, later in this book, it talks about the Royal Proclamation of 1763 by George III of Britain recognized Aboriginal title, directing that lands and resources be acquired from Aboriginal peoples only by the Crown and only by treaty. Not final land claim settlement agreements. Those are not treaties. Not by incremental agreements that provinces, for instance, offer. Those are not treaties. There's been all sorts of ways that federal and provincial governments working together and using corporate entities have tried to give effect to this evidence of having abandoned and given up and surrendered. That is why I constantly say those efforts are unconstitutional and unlawful, because it's clear it can only be done by treaty, an actual treaty. It says, although this instrument had been binding on the Crown for more than 200 years, it was given a fresh impetus by rulings of the Supreme Court in the mid-1980s. And this gets us back to the Section 35 doctrine, which recognized that Aboriginal title existed by virtue of their long possession of the land. In other words, whether or not the Europeans recognized their ownership through treaty. This is this effort to change the law, to change the constitutional foundation of what must be met in order to get more from the Indians. Okay, this, and I use the term Indians because that is what's used in the treaties. So I'm simply referencing those earlier times. So all of these new finagled domestic efforts, they're all trying to change the law. And it only works if Indigenous nationals go along with it. And that's the problem. You've got chief and council, whether they understand it or not, whether they care or not, they're helping make that happen. And I think I'm going to leave it there. Oh, sorry, one other area I wanted to talk about, and that is, in concert with that, this diminishing of the Department of Indian Affairs. And it speaks about Dan Goodleaf, who at the time of this book was a 45-year-old Mohawk, was Deputy Minister of the Federal Department of Indian Affairs at the time. Presided over the dissolution of his department with an energy born of anger, justifiably roused by some of the bureaucrats' patronizing ways. He said, as a Mohawk from Kanawaki, I consider Montreal a suburb of a reserve. He told me, that's Peter Newman, in 1994 interview. Quote, if I had my druthers, my department would vanish much faster than the current timetable. But you don't simply take away without having some replacement for an essential conduit between government and Aboriginal people. 7 years ago, the department had a complement of 6,000. Today, I'm down to 3,400, and there will be even more reductions. As it is, 84% of my budget is managed directly by First Nations, but that doesn't mean accountability is being lost. We're not just proposing to hand out $5 billion without reporting structures, but it will be the receiving communities that become responsible for doing the proper accounting. The receiving communities have no ability to act as the proper check and balance on monies going into bank accounts of chief and council. We have had, and I have special episodes talking about the conversion of collective assets into the hands of a few private people. This squeezing of being able to get something done through the department that's required to be done, like processing a lease, this squeezing and making it take longer and lost opportunities. Instead of attacking the fact that the paid for secretaries that are supposed to do the bidding of the Indigenous nationals, instead of them doing the right job in a timely way and being properly funded and staffed, are being reduced to, to nothing. And so what that forces people to do is to think, oh, well, then, yeah, we need First Nation Land Management Act, because then we can do this stuff ourselves and we'll get it done. Just passing off the responsibility and the cost. The exercise is twofold. One, casting off the unlawful interferences with Indigenous governance. Two, making sure that what is supposed to be done and paid for by Canadian governments is actually meeting the kinds of standards necessary in order to process and do the business required. And that's all I have to say.